Breaking tonight, new developments on a pair of rulings today on Obamacare that could ultimately lead to the law's dismantling. Welcome to the Kelly File, everyone. I'm Megyn Kelly. The powerful D.C. Circuit Court of Appeals concluding this morning that the way the federal health care exchange, healthcare.gov, is set up violates the law. Specifically, it concluded the subsidies offered to make health care affordable were never approved by Congress. According to one Harvard public health scholar, the ruling, if upheld, will, quote, significantly cripple Obamacare. Another liberal scholar agreed, writing in the left-wing New Republic, quote, there's no use sugarcoating it. If this ruling is affirmed, it would throw the law into chaos. The vast majority of beneficiaries would be suddenly unable to afford their premiums, and millions of people would drop out of the insurance marketplaces. The health care law does provide for subsidies to make insurance more affordable for some. But it says that that help can only go to folks who buy insurance through an exchange, quote, established by the state. Got it? The state, not the federal government. Problem is, only 14 states and D.C. even bothered to set up an exchange. The other 36 let the feds do it through healthcare.gov. Remember that, Joy? All told, about 5.4 million customers got their coverage through that problem-laden website. And nearly 90% of those receive federal subsidies. Subsidies that have now been ruled illegal. If the D.C. decision stands, all hell will break loose on this already chaotic law. Premiums will skyrocket. People will lose their coverage. And the dreaded death spiral, where not enough people enroll in Obamacare to make it work, could very well doom this law once and for all. However, another very similar case was decided today by a different appeals court. That one came down in the administration's favor. The Fourth Circuit Court of Appeals in Virginia ruling that Congress probably did mean to allow these subsidies, whether the exchange was a state or a federal one. Bottom line now, this will go to the U.S. Supreme Court. But in the meantime, millions of people face yet another round of uncertainty when it comes to their health care, something near and dear to their hearts, all thanks to a law most Americans never wanted. Jonathan Turley is a constitutional scholar and professor at the George Washington University Law School. Professor, good to see you tonight. And so the administration suffered a bad blow in the D.C. Circuit Court of Appeals, but a victory in Virginia. How is the Supreme Court likely to rule?
Well, it's an interesting problem. You know, these two circuits are divided barely by a river. You stand on one bank and the health care is in robust health, and you stand on the other and it's on life support. So it's a real conflict. These judges looked at the same law, the same language, and came to diametrically opposed views or conclusions. The real dividing line here is how these different courts viewed the role of agencies. You know, the Fourth Circuit basically said that they would defer to the IRS. And what the IRS said is the meaning of the law is the meaning of the law.
And let me just jump in, because this is yet another circumstance where Congress failed to say all that much in the law. They said state exchanges. But the IRS said, don't you worry. By states, they didn't mean states. They mean states or the feds. And we're all too happy to start rewriting the law, even though the people's representatives were not there to approve it.
Well, I have to say, I agree with the D.C. Circuit opinion. I don't see the ambiguity. In fact, I find it rather odd that a line that says that tax credits are linked directly to states with state exchanges is viewed as somehow ambiguous. What happened is this interpretation, as you noted, came out when a very unexpected event occurred, when 36 states decided not to create their own exchanges. And that promises a possible exodus and a cascading failure of the ACA. And the administration stepped in and avoided it through this active interpretation. But what's really involved here is these decisions really are not about health care. They're about how powerful federal agencies have become. The Fourth Circuit says the law is what the IRS says it is.
Who elected them?
And the D.C. Circuit, well, the D.C. Circuit says the law is what Congress wrote as its meaning. So it's a real sharp dichotomy. But I think what you're going to see is the Obama administration will appeal this not first to the Supreme Court, but to the D.C. Circuit as an en banc decision.
Right, because it was a three-judge panel that issued this ruling against the administration today, but they have the right to ask all of the judges on that Court of Appeals to sit. But that's just the next step, and if that court rules in the administration's favor, it's still going to go up to the Supreme Court, is it not, most likely?
I think it is. I mean, the fact is, this is one of the largest federal programs ever attempted. It should not go forward with questions of legitimacy.
And what happens then,
Professor? These are very significant questions.
If this goes up to the U.S. Supreme Court, and let's say the Supreme Court rules in favor of the D.C. Circuit, as they did, and they say, you know what, the law said you only get these subsidies if it's through a state exchange. It didn't say state or federal. It specifically said state. And that's how we're going to interpret the law, the way Congress wrote it. If they say that, then you have people across the political spectrum today saying that cripples Obamacare. That will gut the law, is what happens. Because at that point, we're a year from now, at best, and people have the subsidies. They've bought the insurance. It goes away. Those subsidies are now illegal. Healthcare.gov gets shut down. What happens?
Well, it will be a bloody mess. The problem is that the president was found by the D.C. Circuit to have exceeded his authority, to have violated, again, the separation of powers. But in this case, that violation led to the commitment of hundreds of billions of dollars in the past and future years. And that is a serious problem. Now, no one's going to ask those people to pay the money back. But the entire premise of the ACA, its viability, is then at risk. I don't see how the ACA can survive without this system, at least in the form as it was originally designed to have. Now, does that mean it'll collapse? Well, it would collapse unless Congress would be willing to make massive changes and massive subsidies to back those up.
And good luck with that, with a GOP-controlled House and the law more unpopular than ever. Professor Jonathan Turley, thank you.
Thank you, Megan.